you all for appearing today. Mr. Schwartz, I have a series of questions I want to ask you just to establish some baseline facts about arbitration, but since the professor just mentioned you by name for disagreement, would you like to respond
Yes,
to her
thank you.
disagreement with you that arbitration, I think she said arbitration fees are higher than court fees?
I'll submit the rules of the American Arbitration Association. The payment is not more than $300, and there's one-way fee sharing. If you win the arbitration, all your fees are reimbursed. I will submit the rules to the committee, and I'd be happy to send a copy to the professor so she can look at the rules of the American Arbitration Association.
You said $300, is that $300 a day?
No, it's an immediate fee, that's it.
Okay.
And I will submit the rules to the committee. The rules don't lie, but people can speculate about them. Take a look at them, Senator.
Okay, thank you. Now I want to go through these questions that I have just to establish some baseline facts. The point of having a court system, Mr. Schwartz, is so that people who have been wrong can have a fair and efficient system hear and decide their claims, correct?
That's right.
Are state and federal courts backlogged and overburdened
Yes,
as a
they
general
are.
matter with cases right now?
Before COVID, they were backed up. Now it's about 18 months until you can have your case heard. Meanwhile, you have medical expenses, you have other situations where you can't work, where it can be heard much more quickly, sir.
Okay. Is it true that arbitration is typically faster at resolving those claims and taking some of those claims to the court system?
We can submit information to you, and it's much, much faster.
Is it true
Courts
that
are delayed in jury picking. And I want to mention something about class actions, because this committee should look into how class actions are used. In many situations, the lawyers end up with quite a bit of money, and the members of the class don't. And I see this every year, where they're willing to settle, and frankly, sometimes defense lawyers settle because they want to get rid of the case, and the ones who get the benefit are the lawyers and not the victims who are supposed to be helped in the class. So this committee looks at different things. Class actions should have their original purpose of Rule 23 and not be abused.
plaintiffs in arbitration can recover the same kinds and amounts of damages that they would get in a court?
We will submit information that is true. Stanford study shows the amount of damages don't vary between arbitration and court.
So academic studies show that the amount of recovery does not vary, is not materially different between a court and an arbitration.
Stanford study, which is respectable, shows that.
Is it true that arbitration is more flexible than the court system? For example, that arbitration can occur anytime and anywhere that's convenient for both parties rather than a courtroom on the judge's schedule?
For people with regular jobs, it is much better. With people with families, dragged into court is no fun. This can be done at a nearby place where people live, at a time that's convenient for their job. And so I appreciate that question.
And claimants in arbitration, they can have a lawyer, they can get discovery, they can get relevant materials necessary to prove their claim.
Yeah, discovery is lengthy, costly, and disruptive. That's for sure, because I've been involved in that for years, and I don't want to be on the wrong side of that one.
There's also been a lot of NDAs, non-disclosure agreements, or secrecy agreements. Just to be clear, that arbitration agreements and non-disclosure agreements are not the same thing, correct?
That's correct.
Okay.
Non-disclosure agreements are a separate piece, and they're used in litigation when you settle a case. You sign NDAs. But you can't muzzle somebody from giving the results of arbitration or complaining about it.
Okay. My time is almost up, but it sounds like from your testimony, you believe that arbitration is less expensive and faster than federal courts, that claimants tend to do just as well as they do in court. They can make their own decision whether to publicize or talk about their claims, and that in general, they're going to do better based on your earlier testimony too, from relative to what they would in court versus what the lawyer can take of their cut. Is all that correct?
From a practical reason. And it is important to remember that with many of these disputes today, you can't get a lawyer. So an employee who has a case that's $100,000, lots of luck for them getting a lawyer because the contingency fee system doesn't provide an adequate reward for the plaintiff's lawyer. It's either arbitration or nothing. It's not comparing it to the court. I've made that point in my testimony, but I think it's important that it be in the record, sir.
And this is why, as the Supreme Court has acknowledged, that federal law and policy has generally been favorable towards arbitration going back almost 100 years now to the passage of the
Surprisingly,
Arbitration Act.
it's an area where the court's been in agreement. They fight each other quite a bit, but in this area, they've respected the Federal Arbitration Act.
Thank you.